Welcome to Learn Law Better. Do you need help understanding res ipsa loquitur? Is this Latin phrase keeping you up at night? Stay to the end and learn what it means and how to use it on an exam. And don't forget to hit the like button if you find the episode useful. Hi, this is Bo Baez, and today I want to discuss the torts concept res ipsa loquitur, a Latin phrase which translated means the thing speaks for itself. Though for something that should speak for itself, it sure causes a lot of confusion. First, the context. In negligence cases, a defendant can only be found guilty if the defendant breached a duty owed to the plaintiff. But sometimes there is no direct evidence that the defendant did anything to violate the duty of care. For example, suppose that someone owns a 10-story office building and one of the sealed windows towards the top pops out and falls down, severely injuring a pedestrian. At the time the window fell, the office was vacant. In a lawsuit by the pedestrian, the building's owner might try to argue that he doesn't know why the sealed window popped out and therefore wasn't negligent. What do you think about that argument? I mean, it does have a certain appeal to it, but at some point we should all agree that sealed windows in office buildings should not just pop out. To combat this silly argument, res ipsa loquitur was born when the only evidence is circumstantial. Circumstantial evidence allows a jury to make an inference based on what is known. In the window example, we know that there was a sealed window and that it popped out. The inference is that the building owner breached his duty of care. Second, some history. The phrase res ipsa loquitur comes from a British case called Byrne versus Bodle, which I will cover in another episode. For our purposes today, all you need to know is that we would be better off if the court had not used Latin and instead said it was providing a rule for the use of circumstantial evidence in establishing breach of duty. Third, the rule. The question of what evidence and instructions can be heard by the jury is up to the judge. In a res ipsa loquitur case, the judge will allow the jury to get a res ipsa loquitur instruction if the following three elements are met. 1. The harm suffered is most likely caused by the negligence of someone. If it was an act of nature, like a hurricane, then the plaintiff loses on this element. 2. It is more likely than not that it was the defendant's negligence. There has to be some connection to the defendant, and it has to be fairly apparent that the defendant breached his duty of care. Some of the cases that you read might state this element differently, saying that the defendant had the exclusive control of the object which caused the harm. These cases tend to be older, and those cases never held for absolute control, which is why the more modern rule states that it is more likely than not the defendant's negligence. After all, how else does a sealed window inexplicably pop out of a building unless the building owner was negligent, either in installing the window or failing to make reasonable inspections? 3. The plaintiff was not at fault. Obviously, a plaintiff that contributes to the negligent act cannot use res ipsa loquitur. Keep in mind that by proving all three elements, a plaintiff does not automatically win their case. What the plaintiff gets is a jury instruction that allows the jury to make an inference that the defendant breached the duty of care. The jury can decide to make or not make the inference. Fourth, use on an exam. Treat each element of the res ipsa loquitur test separately. This means providing one full IRAC paragraph for each element. If you try to put it all together, you're going to have one big res ipsa loquitur mess. To be clear, a res ipsa loquitur discussion requires 4 paragraphs. The first paragraph will mention the phrase, that it is used to get an inference for the breach of duty, that the judge makes a decision as to whether the jury gets a res ipsa loquitur instruction, and that the jury is free to either accept or reject the inference. The next paragraph will deal with the first element. The third paragraph deals with the second element, and the final paragraph will deal with the third element. One paragraph for each element. Finally, I hope that my request for you to hit the like button speaks for itself. If you'd like to see more episodes that can help you succeed, hit the subscribe button. Also, don't forget to check out learnlawbetter.com, where you will find more resources to help you get ahead, including my blog, newsletter, and exam bank. Thanks for watching.